I'd like to welcome all to the wonderful to the Quantum Business Laws and Quantum Family Offices monthly webinar. We're very grateful for having everyone in attendance today, and we're intending to talk about some issues that are pertinent to all individuals in Canada in business and all individuals that happen to have involvement outside of Canada. So we're really addressing this to both groups. I'd like to start off by just introducing very briefly our expert panel. I'd like to introduce Michael Miller, a senior partner of Quantum Business Law, who's known as a very analytical individual who brings a lot of capability and ability to resolve problems and disputes between shareholders, between individuals, contractors and employees, and anyone else that runs into difficulties along the winding road that business brings. I'd like to introduce Andy Yip. Andy's a professorial young tax lawyer that is definitely an asset to our group, who's a senior associate. And I'd like to also introduce Todd Louie, who's a master planner when it comes to coming up with solutions for businesses both in Canada and outside of Canada as well. We're going to be talking about a number of different issues today, and one of the issues that we'd like to talk about is the inherent problems with corporate structures that involve U.S. assets, whether it be U.S. corporations, U.S. investment property, perhaps land developers who have interest in the U.S. We also like to talk about planning that involves individuals whose assets are isolated to Canada, but who have recognized opportunities in light of some of the more complicated challenges that have come about. So we say the problems, we're not suggesting there's no solutions, but we're suggesting that there are certain problems. And one of the issues that I would point out that individuals are running into today, partly as a result of the 2022 budget, everything from substantive CCPC rules to various different problems and issues involving companies that are deciding to take advantage of lower tax rates. And usually that kind of a motivation isn't a good one. And although it's been going on for decades, our firm has been warning taxpayers quite adamantly, if you're looking to do planning for the purposes of avoiding taxes, you should be thinking twice. Your planning should be for other purposes. We'll go through some of those things right now. So this is, I guess, a structure that we run into quite often, right? Where somebody's done an estate freeze. We have an active business in Canada. We have property that's held by a corporation that's underneath of a holding company. And then we have two other corporations here on the left side, or two other entities, I should say. Interestingly, we see mismatches. So in other words, a U.S. C Corp makes a lot of sense if you have a corporation in the U.S. that particularly is conducting an active business. Where we see LLCs in the U.S., well, we think that's generally a bit of a problem. And sometimes what happens when successful Canadian businesses expand into the U.S., they seek U.S. advice. And the U.S. advice may not harmonize very well with the Canadian tax law. And one of the issues that we see is that, just to kind of break down the different types of entities in the U.S., we have C Corps, which are much like our limited liability corporations here, insofar as C Corps pay tax as a corporation and distribute dividends to shareholders, whereas an S Corp, well, the individual shareholders are the ones who are taxed. And of course, an LLC has a capability to, as they call it, to check a box and have it treated as a corporation. And oftentimes, there isn't a great deal of discernment when it comes to how to set up the right structure in the U.S. and how to match Canadian structures. Now, one of the issues, of course, with having a corporation, a U.S. corporation, in Canada held by a holding company in Canada, is the fact that you're able to move dividends into Canada at a much less rate. Instead of 15% withholding tax coming out of the U.S., it's only 5%. So that's one of the benefits there. Now, oftentimes where we see situations set up where there's even a small presence in the US. As an example, we had one company that was renting rack space for a computer server for cryptocurrency in the state of Oklahoma. And that turned out to be taxable as US branch taxes. And of course, we know that the Tax Reform Act in 1986 in the United States had implemented this whole issue about branch taxes. There's also what's called FERPTA. Of course, we're dealing now with a situation where you have realization of income from real estate in the United States, and that it's subject to withholding taxes of 15%. And of course, it's up to the buyer, the purchaser, to withhold taxes that would normally be paid to the vendor. And of course, if there's a foreign buyer, well, this is one of the things that often isn't really looked at properly when setting up a US and Canadian structure. So what I'm getting at is it's critical to seek proper US counsel, tax counsel, to get the advice from US tax counsel in order to create an integrated type of plan that embodies the Canadian tax concerns along with the US tax concerns. In the past, we've talked a lot about Canadian advisors acting in silos, accountants, lawyers, and so on. Well, it's even more important when we're dealing in various different jurisdictions. Now, there's a lot of problems with this structure, and maybe I'll just open this up to the panelists to begin with, to talk about what kinds of issues that we can see with this structure. But before I do that, I want to talk about some other things that I want everybody to think about. I've had a lot of clients, our family office and our law firm have both had clients that have come forward and say, look, we want to leave Canada. We have built up a significant amount of assets. We want to move to other jurisdictions where we're going to pay a lot less tax. Well, I'm going to suggest to you that if we look at the OECD's guidelines on base erosion, on BEPS, one of the big concerns for erosion of profit sharing relates to what has happened in the two-pillar system. The first pillar, of course, for international tax planners who have to be concerned about this is where we have companies that have over 750 million euros of sales, say $1 billion Canadian or whatever that works out to be. Well, there's a requirement for a 15% minimum tax on any one of the 140 odd OECD countries. And that's pretty serious. So the companies who have been looking, multinationals who have been looking to try to pay less tax, well, some of those opportunities have closed. Now, why is that a concern if you're not a multinational? Well, it's a concern because we know it's coming. There are still lots of people that like to set up in various different jurisdictions, in low tax and no tax jurisdictions, in order to improve their situation. So here's the reality. Don't think for a minute that what they've started off with multinationals and these large corporations with over 750 million of euros in sales, don't think that won't eventually become the reality for smaller companies. And the other thing, of course, the pillar 2 of the OECD regulations that have been imposed through all the G20 nations is taxing income where the end user resides. So oftentimes digital companies, the likes of Google or the likes of many Amazon and many other companies that operate digitally have been able to take advantage of things that have in many cases been eroded and eaten away. So at the end of the day, when it comes to this wonderful world of tax, we have to ask ourselves, what's left open for us? What can we do? Well, there's a few amazing things that can be done. And when we work with lawyers and accountants and business owners, we like to believe that there are many things that often get overlooked. And the fact that this structure is so common. Oh, we've done the estate freeze already. We don't have to worry about it again. So if you're an accountant that has a client that perhaps has done an estate freeze a number of years ago, you not only have to be concerned about the 21-year period, you have to be concerned about the fact that there's other issues. So let's start this off. And I'm just going to invite our expert panel comment on what they might think might be some of the issues, that they would look at this structure and ask themselves, how can it be improved? So I want to just open that up to our group. Yes, Michael.
Todd, I just wanted to point out, to emphasize the importance of what you just said. The 21-year-old trust, if it's not dealt with, it would be a deemed disposition at the end of the 21 years at fair market value. So that's quite a serious thing for people who set up trust years ago and haven't looked at it or followed it or been getting the right advice. All of a sudden, everything you've done to protect yourself for the last 21 years is gone.
I've run into that at least 3 or 4 times in the last few months, where companies have done a freeze and they have gone past the 21-year period. And of course, it's too late. So, Andy, what happens at the end of the 21 years? From a tax point of view, what's the consequence?
Well, as Michael pointed out, the trust will be deemed to dispose all its assets at fair market value. And in often case, the assets are appreciated significantly, and there'll be a huge capital gains tax payable at the end of the 21st year.
Should you wait until year 21 before you do something?
I think we usually recommend clients to do a rollout before the 21-year will have hit you. And by that, we can do a tax-free rollover to do a new freeze, basically, or use a new trust to basically defer the 21st year deemed disposition.
Yeah, perfect. What about these having one holding company for all these different corporations? Do we see any problem there?
Well, the primary concern when we look at a structure like this is usually the loss of eligibility for lifetime capital gains. By commingling the assets, you basically disqualify the holdco as a QSBC, or qualified small business corporation, thereby losing the taxpayers' eligibility to the lifetime capital gains.
Yeah. I mean, it's rather unfortunate, that the awareness of these issues isn't there in the case of many planners that set these structures up. And sometimes there's just no planning to speak of. Sometimes it's very complicated. So what we're saying is that, accountants who are, writing steps memos, sending them to corporate lawyers sometimes are not necessarily aware of the tax structures or tax implications of the structures that they're building. And accountants certainly can't be expected to be experts in legal structures either. So often what we see is these fundamental problems that are built within a structure that has an international component. So what we'll talk about, I guess, is just a few solutions here. And here we have a couple of solutions that I think make some improvement. We've drawn in the butterflies, right? I'm wondering, before we go any further, we just take a step back. Because what we're really saying is, in the first slide, we have a fundamental problem where we've commingled Canadian assets, such as the Canadian Realco and the Canadian OpCo, and we've connected those in a way to these C Corps and the C Corp and the LLC. So what we'd like to do, where we see these situations, is fix it. So we would set up a second holding company. So here we have holding company 1, and what we've done is we've separated those companies out from underneath the original holding company, leaving holding co 2 to hold the other 2 corporations here. So this is essentially the way that would work. So Andy, I'm wondering if you might just take a minute and help people understand what these butterflies do and what the purpose of them are. We've just drawn this little slide to help people get a sense of a butterfly.
Sure, of course. Basically, single wing butterfly is a tool allow us to move assets in a tax deferred basis. So, for example, in our earlier structure, the assets were commingled, and in order to purify the corporation such that the taxpayer would have access to the lifetime capital gains exemption, we remove the non-active assets out of the holdco. If we can go back one slide, for example, we move from holdco 2 to holdco 1, the US assets, which would disqualify the holdco from QSBC. And by the way we do that is by a single wing butterfly, which involves a series of transactions, including well, Section 85 and sometimes stock dividends. And basically the point of the single wing butterfly is to move assets on a tax-deferred basis.
Yeah, yeah. So I think needless to say, this kind of planning is not typical. And I can remember one time being in a presentation and the presenter was talking about a single wing butterfly. And he asked the audience, it was over 500 CPAs, or at the time, I guess they called them CAs, but he asked them, how many of you have done a butterfly? And I don't remember a single hand in the room. So I believe that this is considered to be pretty exotic. And I think Andy's explanation is, a simplification of really what this does. And what we're really talking about, there's a few different kinds of butterflies. There's what's called a double wing butterfly, which generally means we'll take the assets of a single corporation and we'll split them into two separate corporations. And it's one that's also known as a corporate divorce. So sometimes you'll have, shareholders that are both involved in a single company, and for whatever reason, they want to, they want to go different directions. And oftentimes, and for other reasons as well, we can split companies up, but it really results in the dissolution of the original corporation. And it involves setting up two new companies. And of course, there's a pro rata distribution of different asset classes that have to be done. And generally, we have to get opinions from, CRA on those kinds of transactions. But when it comes to single wing butterflies, I think there's something that it's pretty hard to imagine being able to do effective planning without, because at the end of the day, as you can see, Holdco 1 and Holdco 2 are entirely disconnected, other than the fact that the trust at the top happens to hold shares of both. So essentially what we've done is we've created a lot of benefits for this particular client that he didn't probably even know that he had to worry about. One of the, maybe Jordan, you could explain to us exactly what the benefits are, and also talk about the freeze. We've done an estate freeze, which a lot of people, for whatever reason, don't do. So maybe Jordan, give us an example, give us an explanation of that.
Sure. So estate freezes are mainly done here in Canada in terms of being able to limit or mitigate the taxes payable on the growth of the shares of a corporation or other assets in some cases. And normally, and so here we would be enacting an estate freeze of the operating company, the real estate company, as well as the U.S. corporations. And so what it allows us to do with the Canadian active business assets would be the ability to have the new growth of the company to be passed on to the trust. So we're able to effectively multiply the capital gains exemption using potential family members of the shareholder. So instead of having one capital gains exemption that's worth about $880,000 upon the sale or disposition of the shares of the company, you may potentially have four. You may potentially have six, depending upon how many family members are designated as a beneficiary of the family trust. The other reason why we do an estate freeze is to be able to pass future tax liabilities on to the beneficiaries of the family trust. So in this case, upon the death of the shareholder, the only tax that would be incurred would be the value of the preferred shares that would be held by the shareholder at the time of the estate freeze. All of the future tax liability would be passed along to the next generation and would be taxable upon their death, or if they were to again enact another freeze of the company's shares, then they can in turn pass the tax liabilities on to the next generation as well.
Mm-hmm. Yeah. Now the other thing that we've done is we've added a Barbados trust, and a little bit later we're going to be talking about private trust companies. We're going to be talking about Wyoming trusts. We'll talk about various different international vehicles that can be used in the context of domestic tax planning. And one of the issues that we have to be really aware of is the fact that where we're doing planning that involves the use of foreign entities, it's very important that we're abundantly aware of the substantive CCPC rules in the budget 2022, and the fact that there's been many abuses of the tax guidelines, the tax code, that have resulted in individuals avoiding tax. And I'm talking about the general anti-avoidance rules that CRA has been able to apply in those kinds of situations. I would go a little bit further to say that there's proposed legislation that will have the effect of eliminating certain kinds of planning. Now, what we're really talking about here is setting up a trust outside of Canada. And we have many reasons that we believe that Canada is not necessarily an ideal country for trusts, although we do set up a lot of domestic trusts in Canada. But it's a good situation, but a better situation is to go to a jurisdiction that is more favorable to debtors versus Canada being a creditor-friendly jurisdiction. And I'm saying that for a number of different reasons that we've talked about. I'm thinking of case law that exists, and one case in particular was a case where the Supreme Court of Canada had rendered a decision that stated that individuals needed to be concerned about who their future creditors are. And in moving assets from one company or one entity to another, they had to take into account to ensure that they were not hindering any future creditor. And this is something else that I think is a good reason to look at setting up trusts outside of Canada. So here we have a corporation, a C Corp, we have an LLC. In the US, we've got these Canadian companies, and now we have a Barbados trust as well. So some of the benefits that you'll derive from having this kind of planning involve significant amounts of tax savings. And there's a lot of ways that we can sort of walk you through that. But I think at this point, I want to sort of jump down and talk about the CCPC rules.
Just before you do that, can I interrupt you for a moment? What you just mentioned about future creditors, that's known or unknown. What you ought to have known were potentially future creditors. So it puts a huge onus on the taxpayer to do that. And secondly, I wanted to commend you on using Canadian monarch butterflies in your diagram.
Of course. Well, they're only in Canada, right?
Thank you.
Butterflies. Not the actual animals, but the
Right.
butterflies that we get. All right. So here we have a situation where, we have individuals that have decided to take a Canadian corporation and to continue the corporation into another jurisdiction, possibly Delaware or British Virgin Islands. And of course, we know that this has been on the radar for a very long time. And despite the fact that it's been widespread and that lots of you in attendance today probably have this structure, well, it's something that you need to worry about. And there are ways of resolving it that we can talk about. But CRA will be looking at these structures because they're entirely artificial. So our message is avoid artificial sort of structures. And here we have another example of a situation where a Canadian company has been established, and the shares of the Canadian company are held by a corporation outside of Canada, where Canadian shareholders are at the top. Well, that is indirectly controlled by Canadian shareholders. So the wording in Budget 22 really is focused at capturing these sorts of artificial structures. And not only are they artificial, but they lack purpose. The only purpose for setting up these structures is to avoid tax and nothing else. Well, that's not acceptable. So I think that one of the major concerns is what can be done that can protect assets and provide benefits. Well, one of the things that we do when we utilize this structure is we essentially have a trust company. And we're talking about a licensed and insured trust company, say in Barbados and New Zealand, one of various states in the US, including Wyoming, that I've mentioned already. And in effect, what we do is we have this corporate trustee involved. We have the family getting involved, where we form a committee of protectors. The committee of protectors would provide a written letter of wishes to the trustee, who isn't legally obligated to adhere to them or follow them, but it's a request. And obviously, the ultimate situation is if a committee of protectors decided to, they can easily terminate the trustee and appoint a new trustee. But it's the trustee really that has control of the trust itself, but not of the underlying companies. The underlying companies are the directors are the entrepreneurs. They're the individuals who are running the company here in Canada, or perhaps the companies in the United States. So essentially what we're doing is we're achieving very, very superior asset protection in jurisdictions that do not have unfavorable legislation, such as the Statute of Elizabeth, which goes back to the 1600s. And of course, its wording is that if you're attempting to hinder, to delay, or defraud a creditor, well, a court can make a special award that would pierce a corporate veil or break a trust. And of course, we're aware of the fact that this, as Michael has just correctly pointed out, it also involves creditors that you don't know you have. But to the extent that we're talking about future creditors, well, who could those be? And do we really want to just be able to go along a road sort of blindfolded, not knowing where we could lose our assets? Well, one of the major benefits of this kind of planning is that we can actually have a much more favorable situation for our passive income. So capital gains, we work with a lot of companies that feel a need to improve upon their asset protection strategy, but it results in a much lower rate of tax as well as a natural consequence. So tax on capital gain, rather than being 25% inside of a corporation, is only 13.25%. And where we're talking about passive income, instead of being over 50%, is 26.5%. So what we've done here, we're just sort of giving you some ideas as far as what can be done, but I'm going to suggest we've created conduits. We've created ways of flowing funds, where we're talking about moving assets from a holding company to a sister company. Well, oftentimes we do that for other reasons. And one of the main reasons is because we're seeing banks, insurance companies, investment advisors, life insurance salesmen, life insurance agents placing assets inside of holding companies. Should never happen. Should never happen for a number of different reasons. But one of the primary issues that you got to be aware of is the fact that number one, you may be losing your capital gains exemption because the shares of the holding company may need to be sold in order to claim a capital gains exemption. And therefore, the presence of a life insurance policy, as an example, or investment fund that has cash value can cause the loss of the capital gains exemption. The shares of the holding company are no longer qualified as qualified small business corporation shares. But what we've done here is we've created an ability to be able to move money, particularly from a C Corp. We may want to do something with the LLC, but we want to be able to move funds into Canada at a greatly reduced withholding tax of 5% instead of 15%. And then we have funds sitting in the holding company. Well, you're not going to have a capital gains exemption. Consideration should be given to the holding company to say, do we want the shares to be controlled by the Barbados Trust? Well, we should want that. And if we do decide to put that into place, since U.S. is a highly litigious jurisdiction, since the assets and future growth of this company can be secured by a Barbados Trust in such a way that we have voting control held by the trust with full accountability to the trustee by the family in a way that makes everyone comfortable with this kind of structure, it can result in about half the rate of tax, which is just again, it's a natural consequence of what we are trying to achieve. But then ultimately we create conduits, which allows us to be able to move money into another company where we essentially segregated off to the far right side the non-active Canadian assets. And of course, we can, by doing certain kinds of planning, the assets can be transferred to this sister company. And we call it a sister company because it has the same parent as the holding company. And one of the things that we always are looking at is what tools can we use to achieve a superior result? Well, life insurance has a sacred status, and Quantum Family Offices is very much involved with dealing with a number of different products that do have tax advantages. And life insurance happens to be one of them. And I'm saying it's sacred, or at least the status is sacred in the Income Tax Act, for a number of very valuable reasons. A lot of people don't realize this, but where you purchase a life insurance policy, there is no, by a corporation, there is no tax on the death benefit, which I think is a critical issue. When you're able to use after-tax corporate dollars to pay for insurance, of course, the value, the cost to you is much lower. Not only that, but if you have a cash value policy, a policy that participates, or as they're called, a participating policy, or say universal life insurance policy, the assets grow completely tax-free within the company, which is even better than paying tax at a reduced rate, but up to certain limits, it's tax-free. Jordan, maybe you could describe this insurance side on the right side of the screen, would you?
Yeah, sure, absolutely. Thank you, Todd. And as Todd had mentioned previously, oftentimes insurance is not placed correctly. It's not placed with the rest of the estate plan or the tax plan in mind. And so oftentimes it presents shareholders with a number of challenges in terms of being able to regain eligibility for the capital gains exemption, as well as life insurance policies also being vulnerable to litigation, to creditors, if they're not placed correctly with the right type of structure. And so in this case, the life insurance, the way it fits in, it's filling certain needs that the shareholder would still have despite doing this type of estate freeze. So there are still taxes that are payable upon the death of the shareholder. Namely, that would be the freeze share value, the preferred shares of the shareholder himself, of these corporations and of the assets within them. So there are still outstanding capital gains taxes that will be payable at that point. There are also other expenses that obviously life insurance is intended to cover. That would namely be income replacement for the shareholder's family, but also key man insurance in terms of being able to cover expenses that would be intended to replace the shareholder in his functions over the company. Oftentimes when you're doing an estate freeze, the other question is, now that you've purified the company, regained eligibility for the capital gains exemption, the question is, how can the shareholder then be able to access this money at a tax-reduced basis from the sister company or from the investment company where the money has now been moved to? And so one solution that we've pictured here, I'll describe it just briefly, as we don't have time to go through all that for several different products or several different approaches. But rather, in the example that we have here, we would be using a whole life policy or perhaps a universal life policy. I mean, there's many different options depending on the taxpayer, the shareholder. But in this case, we would be, in our example, we'd have likely a universal life or a whole life policy that may have a coverage amount or face amount of up to 20 million. And so in that case, the first step would be really paying the yearly premium of $1 million towards the life insurance company for the life insurance policy. And from there, that life insurance policy would have quite a substantial cash surrender value within it as an asset for the sister company. And from there, we would then pledge the policy and the cash surrender value within it as a collateral assignment to a financial institution. Could be one of the top 5 banks, or there's alternative lenders as well. And in that case, and so in return for having the lien or the collateral assignment on the policy, the financial institution would be willing to issue a loan that would be largely equivalent to that premium that's being paid every single year. But the difference is that the loan would be issued to the shareholder themselves as opposed to the sister company. And so through this loan structure, we would be able to give the shareholder access to $1 million every single year from the bank in the form of a non-taxable loan. But there are certain requirements that we have to meet in terms of setting up the structure. So there has to be a guarantee fee that's paid from the shareholder to the sister company every single year. Because generally, if you're using a corporate asset, such as a building or any other corporate asset, to be able to secure a personal benefit, that would be a shareholder benefit. So there has to be a certain fee that would diffuse that shareholder benefit. So there's a fee for services rendered on behalf of the shareholder from the sister company. And so with this type of policy, generally will result in a death benefit of starting at an amount of 20 million, but the death benefit, as Todd had mentioned previously, grows substantially tax-free every single year. And so the way that this type of structure works is that it creates the loan that's created on behalf of the money being received by the shareholder. This loan would be repaid from the death benefit that's received by the sister company. But even after that point, there's still a very substantial death benefit that would be able to be received by the shareholder's estate upon their death. One benefit of these type of policies is that it creates a substantial CDA credit or Canadian dividend account that would enable the shareholder's estate to be able to access money tax-free upon the receival of the death benefit of the company. So all of the remaining funds within the death benefit after the loan is repaid would be able to flow through the company back towards the shareholder upon the death of said shareholder, and flow towards their estate, and it can be distributed towards the family members of the shareholder.
Yeah,
There's a lot of information that we can share in this respect. I mean, all these numbers vary according to the age of the insured, according to the health of the insured, but also the product that's being offered. And so we'd like to discuss these areas perhaps in the following session.
Yeah, so we'll move along and we'll talk a little bit about other jurisdictions, and oftentimes what we do with a similar kind of structure. There may be US connections, there might be preferences to using a trust, say in the state of Wyoming. And of course there's, Wyoming is a very good jurisdiction from an asset protection point of view, albeit we're, again, a very litigious jurisdiction in the United States, but it does make sense in many cases to look at setting up a trust in the state of Wyoming. One of the things that we're able to do in Wyoming that we can't do in many other jurisdictions is we're able to establish a private trust company, which can act and its charter and its capabilities will allow us to be able to operate for one family or for one group of companies only. So this private trust company, or PTC, as we call it, really has a dual role. Not only will it hold the shares of Canadian corporations, but it will also act as a trustee for the Wyoming Trust. Now, in order to create superior asset protection, the private trust company would be held by a purpose trust, and the purpose trust would hold all the shares of the private trust company. We would also have an advisory company, a corporation that would be set up in the US where the family members, the Canadian family members, would be involved in the advisory board as far as advising the trustee on what he on some of the issues, and on a similar way that a committee of protectors would be involved. But we would also have an advisory group that will be part of that, all done in such a way that we are not, in effect, taking control of this trust. Advisory board is just that. Ultimately, the trustees, the private trust company that's made up of an independent board, actually has the decision making to do. You'll take into consideration any recommendations made by the advisory company, but obviously its decision's his. But again, the advisory company is able to replace the advisory group, or sorry, the company that's involved with managing the private trust company for the family. So essentially, we have what I would call accountability. And of course, the same kind of structure that Jordan described can be incorporated into that plan. A lot of people will say, well, what's in it for me? It's great that I'm kicking the can down the road one generation, and I'm not going to have to worry about paying taxes after I die. The estate won't have to pay as much taxes. It'll go to the next generation, which is fantastic. A lot of people would look at that and say, that's amazing. I'm able to create this superior asset protection I can't get in Canada. But how do we reduce taxes on a year-by-year basis? Well, we have clients that have come in and said, well, listen, I've got 500,000, $1 million or more of income every year that's taxable that maybe they don't need to take. Maybe in reality, through the concept of using leveraged insurance, you can have cash value accumulate to the extent that you pay $1 million into a life insurance policy, pledge it as collateral to the bank, and receive $1 million back. So that actually can be done. Now, these are tools that essentially are designed to work together. And this is all about consulting. It's all about knowing what structure makes sense. Some people say your structure isn't your structure like this or like that. Well, these are all very customized because individual families' needs are customized. It all is based upon really just a careful analysis and working with the advisors as well. And somebody said to me recently, I didn't know you did all these things. Well, we'll show you a bit later what the family office how they can help your group. And if you're an accountant or a lawyer, how they can help you and your clients as well in a way that all can collaborate in a meaningful way. The interesting thing, by the way, about, we're going to talk about Bill C-208 later, but up until now, this concept of a butterfly was out of reach for family businesses in many cases. And why I'm saying that is because oftentimes there's siblings, and the act had really not allowed us to be able to where there were siblings, because for purposes of Section 55(2), well, we know that siblings were deemed to be unrelated, and this kind of a transaction could only be done for related parties. Well, the nice thing about Bill C-208, it's kind of pushed that, it's allowed us to be able to now do that kind of planning. So we'll move on a little bit further, and we'll talk about some other international kind of tax planning. We'll talk about individuals that are immigrating into Canada. Oftentimes we have situations where there's corporations in various different jurisdictions. And of course, you know that when an individual moves to Canada, becomes a resident of Canada for tax purposes, there's tax implications. Andy, maybe just touch on what happens when an individual brings their shares of companies and other assets into Canada.
Well, basically the assets would, the taxpayer would be deemed to acquire the assets that previously owned at the fair market value. So that will be their new adjusted cost base. So yeah, not sure like what other topic you have in mind.
Yeah, that's precisely it. So the fair market value of the asset would be the tax cost or the adjusted cost base when they move to Canada. And in this particular instance, we're taking these shares of these companies, and it could be any country, by the way, and we're rolling them into a Canadian holding company. And at that point, we're taking back shares that have an equal value, where they'll be frozen shares. We'll issue preferred shares to the shareholders. And at that point, we would then introduce family members indirectly through this Barbados Trust in this particular case. We have a Canadian investment company that's 100% controlled by Barbados Trust, which gives us this really superior asset protection, far better than we can get in Canada, and also gives you this greatly reduced tax rate that we've talked about. But Andy, maybe you could explain to the audience the what exempt surplus is and how it works in general.
Sure. Exempt surplus is basically is allowed under Section 113 of the Income Tax Act. It's basically an amount or almost an account you keep track where you can bring in into Canada tax-free. So usually when a Canadian corporation receives dividend from a foreign corporation, the amount is taxable. Exempt surplus includes amounts for active business income and in the foreign corporation, where you can bring those amounts into Canada tax-free.
Yeah. So recently we had a company that an individual whose father was moving from Dubai into Canada, and we get these situations often and from all different countries. But where there's a tax treaty or information exchange agreement between Canada and another jurisdiction, it allows us to be able to, subject to certain requirements, move exempt surplus into Canada. And exempt surplus essentially is, income that is active business income that has been subjected to whatever tax regime exists in that jurisdiction. Well, in UAE, there doesn't happen to be one. So essentially, we were able to look at these corporations and look at the activity and look at the number of employees that they had. And turned out that these companies meet the Canadian sniff test from a standpoint of an active business. We were able to bring $30 million into Canada from United Arab Emirates on a tax-free basis. And that $30 million, there was never tax paid to begin with on that $30 million. All completely compliant, all completely within the realm of what the intent of the legislation was. So you see, there's so many things that people are not really aware of, and where you're navigating a very winding road, just to kind of be aware that some of these things can be done are really important. We've already covered this concept of the continuances from Canada to other countries. But what we're really saying here is that whether it's, depending on where the jurisdiction is, we really have that capability to be able to navigate the issue of control, to make sure that, you know, where we're putting shares under the control of a trust in a foreign jurisdiction, that we're able to do so in a way that we can benefit, and the asset protection mechanisms that are all put in place are at the forefront of our planning, right? So here's another situation. I mean, we get this all the time, and a lot of you are accountants or lawyers, but you say, okay, well, how are we going to create a purification structure where, you know, you can't use a trust as an example? Well, this is a very simple thing we do for dentists, professional corporations, physiotherapists, you know, accountants, and so on. Well, you want your shares of your corporation to be pure. We don't want to lose the capital gains exemption. We often will freeze the value at, say, $1 million of the preferred shares. We actually have $1.5 million of cash. So before we do that freeze, we would do a single wing butterfly that Andy described already, to essentially move those funds out of the professional corporation and move them into a holding company. Now, generally speaking, and this isn't a tax issue, it's more of an issue of just what the professional body would state, the governing body that would dictate the regulations. But generally it says that the licensed individual must hold the shares directly or indirectly. Well, in this case, we have the professional at the top of the holding company, and we're able to pay dividends in order to purify the professional corporation, as well as create asset protection. So just another little thought there. So we're kind of covering a large amount of issues here. One of the key things that we run into often is individuals that have vacation property, say in Florida or some other place. Well, the reality is that in this situation, we're able to create multi-tier limited partnerships that can insulate against the effects of U.S. estate taxes. Michael, what's the rate of U.S. estate taxes for property, situs property held in the U.S.? Typically, what percentage?
It can be around 40% of the fair market value today, not the purchase price when you bought your property.
Yeah.
So if you bought a vacation home and you don't do something about it, on the death of one of you, the surviving joint marital relationship person will have to pay 40% of today's value. So if it went up 100% because you bought it 20 years ago, it's money directly that you're giving up that we could have saved you money.
Yeah, absolutely. Absolutely. So if you have a condo in, say, Florida, as an example, well, why not think of setting up a multi-tier limited partnership to hold that condo? And of course, you would have a general partner corporation here in Canada that would be essentially responsible for the day-to-day operations of the partnership. And then you'd have a limited partner, which would essentially be yourself, and you would contribute that property to the U.S. partnership, and the two would be connected. So that's something that's a bit complicated, but we can talk about it a little bit later. I would like to talk about Bill C-208, though. We've already mentioned Bill C-208 as far as being able to perform a single wing butterfly where there are siblings involved. And here we have another situation where we're looking at the tax planning for the family business. Andy, can you talk a little bit about Bill C-208 for us?
Sure. Basically, the income tax at Section 84.1 is a section that aims to stop taxpayer from stripping out assets from the corporation without paying any tax. So previously, this limits the ability from intergeneration transfer or sale of corporation share from, let's say, father to son or grandchildren. So Bill C208, they amended that and give the option, or like makes it possible for family members to sell their corporation to purchase a corporation that's controlled by a child or grandchildren of the vendor. And if certain criteria are met, then it would not attract the punitive section 84.1, including, for example, the shares after the purchase, the share would now be sold for 60 months, and an affidavit would have to be submitted to the CRA.
Very good, very good. So let's break that down into simple English. So let's start off by saying that family businesses are at a disadvantage. If they were selling to a complete stranger, there'd be capital gains treatment on the sale of the shares. That's not so in the past, if there was a corporation buying the shares. Secondly, there'd be no capital gains exemption. Why? Because it's treated as deemed dividends if there was a corporation held by a son or a daughter, and that corporation, that holding company, was acquiring the shares from the mother or the father. Well, the tax treatment of that is very unfavorable historically. Thanks to Bill C208, it's now opened the way for family businesses to be able to do proper tax planning without having to worry about such terrible consequences as having not only losing capital gains exemptions, but having to pay tax as a dividend versus capital gain. Now, a lot of you lawyers and accountants called me during the time, and some of you business owners, during the time when the legislation hadn't yet been amended. Oh, there's a loophole, and there was people running around all across Canada signing up unsuspecting clients to do Bill C208 planning before the wording was changed. And my answer, for any of you who's had that discussion with our group, has always been no. There's always GAR that they can use, and therefore what you're attempting to do by taking advantage of what might be a loophole is going to take you nowhere. And I believe that that's proven to be true. So what we're really talking about is actual change of control. The requirement for Bill C208, the intent of the legislation, is that the father, in this case, or the mother, they've actually retired. They've actually taken a step back from the business. And therefore, the intent of the legislation is to ensure that this is an actual change of control. Not only a legal change of control on paper, but an actual change of control. And the term actual control is one that is a little bit controversial as well. And there's case law that deals with this issue. And what I'd say is, we don't want to leave anything, we don't want to be careless. But what it really allows an individual to do, a son or a daughter, could set up a corporation, and they could essentially purchase the shares of the company using a promissory note. They would then pay dividends to themselves and would then eventually satisfy that promissory note from the holding company to the parent. But we triggered the capital gains exemption. We would have capital gains treatment, plus we'd have a capital gain. We have other situations where we have contractors and other companies. Contractors are sort of a prime example. And I've never liked artificiality. I've said that many times, if that's a word. We see situations where, there's say a land developer and a company on the left, where they're spending money hand over fist. They're developing land, and every year they have big losses. And then in the company on the right, well, they're selling inventory, right? Townhouses, apartment buildings, houses, whatever it is they happen to be selling. Well, this is very, very common in that industry and other industries. So what we will often do is we'll set up a limited partnership. And limited partnerships have fiscal transparency. And therefore, we have a general partner corp that will be involved in managing the affairs of this activity. But the affairs would be done in such a way that we could offset losses with profits without artificial and overly high management fees that are paid from one company to another. So these kinds of structures we do a lot of. Another one is a not-for-profit corporation for cottages. Well, there's a lot of reasons why we believe that a not-for-profit corporation makes a lot of sense for cottages. We're talking about a non-share capital corporation. And one of the benefits is it avoids a deemed disposition at death. In other words, parents, rather than holding the cottage in their own name, they're put it into a not-for-profit corporation, which would really allow them to be able to achieve continuity of ownership to the next generation. So even when they die, there's no taxes to pay on the value of the cottage. One of the benefits of doing this is that you really don't have to worry about it being taxed as a corporation for a number of different reasons. If the corporation is organized exclusively for social welfare, civic improvement, pleasure or recreation, then there'd be no tax effect to the not-for-profit corporation. If the property is sold and a new property is purchased, there's no tax on the sale of the property, and there's no tax on the repurchase. So each family member doesn't actually have any disposition on their death, since they only have a life interest in the not-for-profit corporation. So a lot of complicated things that work very, very well, but we're just sort of brushing over them today to give you an idea of what can be done, right? So here's an example of something that we had a very large law firm in Mexico that Michael is acquainted with, and they had clients that wanted us to help to set up a structure to aggregate investments. And in this particular case, we had an organizer, and we suggested to them they could set up a corporation to be a general partner. Then the limited partnership would be here in Ontario. We suggested that they set up a segregated cell company in Barbados. And a segregated cell company, we don't have them here or in the US. But the way that they work is they have various different cells, unlimited numbers of cells, maybe 20, 30 different cells. So Mr. Rodriguez might put $10 million into Class A cells. Mr. Gonzalez puts $5 million into Class B cells. The assets and the liabilities are entirely separate from each other. And the amount of liability is restricted to the amount of investment that the limited partner makes. Now, the other thing is, in this particular case, this was one of the larger law firms in Mexico. The Mexican wealthy individuals, good business people, were being really attacked by the government on the basis that the government was calling them into their offices saying, come and bring face masks and hand gel, sanitizing gel. Don't bring representatives with you. You're being suspected of tax evasion. A lot of very ethical business people in Mexico were victimized and still are. They're looking at how they can get their money into a safer place like Canada. So this kind of structure can help with that. And the current laws that exist, in it, depending on which country you're talking about, but there's all sorts of issues with civil law countries, forced heirship rules, things like that we can help you individuals to get away from. So if you have clients in other countries that are looking at investing into Canada, one of the big things is there's no tax in Mexico, as an example, and other countries the same, on foreign source income, providing that they don't own more than 50% of the value of the Barbadian segregated cell company. And
but in addition to what you're saying, it also gives people the ability to have a residence that they can move to in times of trouble. So, for example, to come into Canada, there's a better way Todd can describe it, but if you're doing this type of tax planning, there are ways that you can come into Canada almost immediately without having to comply with a whole bunch of other laws that are required of people that don't have this tax structure.
Yeah, that's actually a good point, Michael. I mean, any members of the prior NAFTA, as an example, we can actually get work permits at the border issued to them. And the way that we do that is we set up a corporation in Canada, say in Ontario or BC. They have a corporation already in their home country. And what we do is we second them to the new company. And there's a whole process for that. And we deal with someone, I'm not sure if he's watching, if he is. Hello, David. David Lesperance is a Canadian immigration lawyer living in Poland. I believe it's because his wife owns a vodka company there. So David is part of our consortium and works very closely with us on these kinds of situations. It can help individuals from around the world to achieve all kinds of great things. Often there's Canadian investors too, and we set up a trust that would hold the interest in the cells of the segregated cell company, as well as for Canadians, we can achieve the lower tax rate on investments, of, again, of 13.25%, quite legitimately, all while keeping the main focus in mind as far as asset protection. Truth is, we need a bona fide purpose for what we're doing.
Can I just say one more thing? I'm sorry. I know our time is almost up. We didn't get to wills and shareholders agreements today, which I know is an important part of what we all do and think about. And I don't want our viewers to be frustrated that it wasn't thought of. We'll get to that maybe at the next webinar or sometime in the future. But it's very important to know more about your lack of wills and shareholders agreements than you may be aware of.
Yeah, thank you, Michael. That's true. One of the things that I would like to touch on, and that is an opportunity for individuals who have sold a building that has a significant value, or perhaps just has significant cash inside of the company. And somehow the screen is not working. I don't know why. Try that one more time. In this particular case, we have liquidity inside of a company, and we're able to create a liquidity event. And the way that we're able to do that is, first of all, we would bring in a company that has cash, who would be interested in buying your shell company or your investment company that has liquid assets, and they would bring their own cash. In this particular case, we have an example of $20 million that is sitting within a corporation. The goal would be to be able to access that cash in a tax efficient way. So one of the ways that that's done is we bring in a purchase company, and they would make an offer to purchase this company at a discount of 10%. That means we're looking to pay $18 million for that company. The good news is there's no tax on the 18 million. The way that that's done is we're able to do a rollover of the shares of the investment company to a subsidiary of a third-party company that we bring in. And what we do at that point is we file an election to increase the tax cost to 18 million, or the PUC. Under Section 83(2), there's an election that allows us to be able to increase the tax cost. And the reason we can do that is because the subsidiary company has significant amounts of capital dividend account that are in harmony with the CDA anti-avoidance rules in 83(2.1) and 2.2. So we don't believe this is in violation of any GAR issues, since GAR is the general anti-avoidance rules, and there are specific anti-avoidance rules, such as it can't be, the CDA mustn't have been acquired by an amalgamation, or there mustn't have been a non-resident individual involved, and all of those things. But we're talking about things that we just want you to know they exist without getting into a lot of nitty-gritty as far as how it works. So what we'll leave you with is this idea that accountants and lawyers, financial advisors, life insurance people, wealth managers are coming to our family office because we are basically saying, you know the client very, very well. Business owners as well are coming into this because we're able to watch out for all of these opportunities and all of these minefields that exist, because the accountants and lawyers can't be expected to know everything. There's many things corporate lawyers aren't intended to, don't necessarily deal with every day on tax, and things that accountants don't deal with as far as legal structures. So what we're really saying is all of these things we do. Somebody yesterday said, I seen your webinar, I seen this slide, but I didn't know you guys actually did this stuff. So we do, yes, we talk about it, we do more than talk about it. What we do is we ensure that as you add companies, as you make investments, as your business grows, as your circumstances change, the Quantum Family Office is helping you to navigate this very winding road. We work with existing lawyers and accountants will come in. Well, they have the chairman on that file, so to speak. They have a seat at the family office table. They're involved in being part of the solution. And this is critical. So this is an invitation that we've made, and want to just remind everyone that it exists. So I noticed that we've gone just a little bit over time, and I noticed that there's a few questions here. One of the questions that's being asked is, for the IFA strategy, if the shareholder pays the guarantee, who pays the interest? Well, I guess, Jordan, do you want to answer that? I guess the interest can be capitalized, right?
Yeah, so I mean, there's different options. So I mean, typically we would recommend for the interest in these structures to be capitalized and to be repaid upon the death of the shareholder, which will be, again, added to the loan balance and deducted from the death benefit that would be received by the policyholder. And the other question was if it will be tax deductible. And so so it could be tax deductible, provided that the money is reinvested back into the corporation. If all of the loan received by the shareholder is just being used for personal usage, then it would not be tax deductible. But any portion that he's using to reinvest back into the company, that portion would be.
Yeah.
And I think there was one more question as well, just from Dan. It was if it was a taxable benefit to the shareholder, and so there would be a benefit that is being derived to the shareholder. But that's the reason why we always recommend for guarantor fees to be paid from the shareholder to the company, to be able to pay a fee for the benefit that the shareholder is receiving.
Yeah, there's a question here talking about the not-for-profit corporation that hold the cottage. And the question is, would that not be, a disposition? The answer is yes. So if there's an existing cottage, well, you transfer it in, then there is going to be tax, providing, that there is a gain taken into account any renovations or improvements to the cottage. The other thing is, if you're looking to purchase a cottage, well, why not use a not-for-profit corporation to begin with, right? Which can make a big difference. A lot of other questions here, but we are committed to staying on time. We don't want to hold you beyond the time that we've stated. And I noticed that we're almost 10 after. So we'd like to thank everyone very much for attending today. We look forward to the next session.